Good afternoon. Welcome to an oral argument session of the Sixth District Court of Appeal. My name is Judge Mary Nardella. On my left, we have Judge Brian Lambert, who has graciously agreed to join and help our court in the last year. We really appreciate him. And on my right, we have Judge Joshua Mize. We originally had 3 cases for our consideration. 2 have been continued, so that leaves us with 1 case. It's 23-2683 Rhodes Tucker Phoenix versus 2407 Periwinkles Sanibel. Each side will be given 20 minutes. It is typical to reserve 5 minutes for rebuttal, but if the appellant would like a different increment of time, please let us know. Is 5 minutes acceptable?
Yes, Judge.
Okay. Counsel, I'll just remind you that we are being live streamed, and whenever you're ready, you may proceed.
Thank you, Justices.
Judges.
Please the court. So my name is Chris DaCosta. I represent the appellant who is the tenant in this scenario. They had an office on Sanibel and that they occupied pursuant to a lease. That office was owned by an entity that went through Chapter 11 bankruptcy proceedings and then a subsequent foreclosure. Now, during the early days of the pandemic, if you remember, I think probably all of us did the same thing. We sheltered at home. And what happened at the law firm was let its employees go home. And during the period in which the employees were sheltering at home, the appellee landlord purchased the unit. Now, normally when a landlord purchases a unit that has tenants in there, they go to the property, they see the tenant is there, and they either accept the lease, they work out something with the tenant, or they file for an eviction. Now, it was very clear at the time, at least from my client's perspective, and I think in the record, that the law firm was in occupancy. The lights were turned on, there were furniture, machines. The record in the trial court is very.
Can you walk me through exactly how your client didn't sign the original lease? Can you walk me through exactly how your client became a party to this lease with the right to enforce it?
So
Take me step by step.
So what happened was there was these predecessor entities. There are 2 of them that signed the original lease. And I think that was in 2011. And then in 2014, this new entity through which the principals were operating as a law firm through signed an amendment to the lease that was intended to substitute the Rhodes Tucker name for the.
So how did it actually, so normally when someone's interested in a document being assigned, I expect to see them sign it. So what I would expect to see is either an assignment or a novation, one or the other, signed by the original tenant saying I transfer or assign my interest or novate my interest in the lease to the new tenant. So take me as a legal matter, if you have one entity who's the tenant under a lease and is a party to the lease, they don't sign anything, they don't assign their interest, there's no document by which they transfer their interest, and some other entity signs something called an amendment to a lease, how that automatically takes away the original tenant's interest in the lease. I don't see, I don't know what the legal mechanism for that would be.
So, I mean, I think there are a number of different ways you can do it. In this particular situation, an amendment was prepared.
So you're missing my question. So in order for the original tenant, for their interest to get transferred, they would have to sign something or consent to it in some way, right? That amendment to the lease does not contain the original tenant's signature. So what is the document that effectuated the transfer of the original tenant's interest to your client?
The amendment.
How can that be without the original tenant having signed it?
Well, first of all, Mr. Phoenix, who signed both leases on behalf of those respective parties, he was a principal in the predecessor entities and also in the new entity.
Yeah, but he didn't sign it on behalf of the old entity.
You know, I mean, I guess my point to you is I don't believe that you have to sign an ovation and quite frankly, while that could have been an issue at the time, let's say that the original tenants, you know, for whatever reason repudiated it, it could have been dealt with at that time, but like that was in 2014. Rhodes Tucker occupied the premises pursuant to that lease for another 7 years before all
But
this
you're
happened.
just saying pursuant to the lease. I guess what I'm saying is, what was the legal mechanism by which they actually took an interest in the lease? Because you just said, well, they didn't need to sign it. But I think that's just, I don't know the legal basis for that, you're just saying it. If you have an interest in a contract and you want to assign it to somebody, you do in fact need to assign it. There's two ways, right? Sometimes interests are directly assignable, so you assign your interest, which would leave you still liable, right? And then there's novations, where the original two parties and a new third party agree that an original party is going to be released and a new party is going to come in. So there's multiple ways to do it. All of them involve the original contract party, your tenant in this case, to sign something. So when you just say the words, they didn't need to sign it, I'm going to need some legal authority for that, because I think that's really obviously wrong.
I understand what Your Honor is saying. I would simply say that, you know, let's assume that some sort of novation or signature from by Mr. Phoenix on behalf of those old entities was required. Over time, you know, those issues from our standpoint went away because whatever happened was performed.
Hold on. So is there some legal authority that would say that if you just move into a building that somebody else has leased, that you take over their lease? Like, it seems like you're making a lot of assumptions, and I'm not understanding the legal basis, at least for any of these assumptions. Like, if I had moved in, would we say I took over the lease?
I think, again, I think the practice that actually happened, I understand what you're saying. I understand that you're looking for a signature from the original.
I'm not looking for a signature. I'm looking, is there any legal authority that would have any relevance here? And anything recognized in Florida law of any kind, an authority you can point me to that says someone can transfer their, someone's interest in a lease can be transferred without them effectuating an assignment, an ovation, anything at all to actually transfer it. Is there any authority you're aware of that would make that a thing that exists in the law?
I don't have something for you today, but what I will say about that is like, I also don't believe that the appellee in this situation has standing to raise that issue. If
They
legal
can't say- hold
outsource,
on. If you're suing somebody for breaching a lease and acting inappropriately with the lease, and they don't have standing to say you're not a party to the lease,
we didn't sue for,
but you
breach of the
sued for
lease.
violating your rights under the lease, right? You said you had a right to be there pursuant to the lease and that they violated those rights. So you did sue to enforce rights under the lease. So you're saying somebody sued for violation of a lease doesn't have standing to say the person suing me is not on the lease?
as I stated before, you know, whatever problems that were as far as existed, as far as the origination of that amendment in which Rhodes Tucker took over, that whatever objections may exist, they actually performed on the lease for 7 years. So
The
and
trial
that's
trial judge found no valid lease.
he also found that there was a valid lease, and that's kind of where why
Well,
we're here.
I mean, I know you've argued that, but I mean, he's found that there's no valid lease. And it looks like the lease is invalid. It wasn't subscribed by two witnesses.
Well,
And that was the statute at the time. I know the statute's been amended and that was at the time. So, I'm not sure, kind of what Judge Mize is saying. If the lease is not valid, I mean, I guess, are you saying there was some kind of defunct or an oral lease and somehow the statute of frauds saved it, but there was no argument of partial performance below that was raised in response to the summary judgment. So under preservation theories, wouldn't that be problematic in the appellate world? Why wouldn't it be? I'll ask it that way. How about that?
I mean, one of the part performance was actually talked about when they appellee moved to dismiss, and the court actually wrote an opinion stating that one of the reasons that denial of motion to dismiss was warranted was because we had a valid claim for our performance. And I think the record it shows that there was.
That's
I
good.
mean,
I know you paid you said you paid the prior landlord. You didn't perform this to this landlord. I know you mentioned that we had all these lease credits, and you say that a lot of times in your brief. I didn't see any law that says if you pay one landlord, right, and then the owner of the building changes, that credit follows to the new landlord. What I would think is you have a claim against the prior landlord who you paid, right? Maybe in their bankruptcy. Just saying we paid one person, but there's a new person, and the new person is charged with credits for everything we paid to the old person. I saw you say that. I didn't see any legal authority for it. You kind of just assumed it. Is there any authority for that being a thing that exists?
well, what I would say about that is, part of the problem here wasn't, I mean, if we were just before the court on a breach of the lease, that would be one thing. But what happened in this particular case was whether they were there as pursuant to a lease or not, Florida law is very clear that you can't just go in, change the locks and take their stuff.
Counsel, I asked you a question and you proceeded to not answer the question. So answer my question. Is there, when you pay one landlord, you have prepaid rent and the ownership of that building transfers to a new landlord because the property is sold. Is there any authority for the proposition sprinkled throughout your brief that those credits transfer and are held against the new landlord?
I mean, I would simply, you know,
It's the crux of your
yeah,
brief. So I mean,
yeah.
that's like a huge issue.
if
Is there any authority at all to support it?
if the lease is enforceable, it's enforceable against subsequent assignees.
Well, that's a different question than whether or not prepaid rents to one person can be charged against another. Is there any legal authority for that proposition? It's a simple question.
And my answer is, you know, a contract law. The basic, if someone is a successor interest on a lease, they have the obligations that come with that, which includes crediting rent payments.
Counsel, your position seems to be in your brief is that your opponent has taken inconsistent positions and that's prejudiced you. When it comes to the appeal in front of the second DCA, there was a motion filed for appellate attorney's fees by 2407, correct?
Yes, Judge.
And it resulted in an order from the second DCA awarding appellate fees. Is that motion in the record? And maybe you need to sit down when you have a chance and look. But my question is anywhere that motion in the record which shows us the basis on which they moved the second DCA to award appellate fees?
Honestly, I really don't know the answer to that question.
No, I understand. Thank you.
And so, I mean, I've spent a lot of time talking about the lease and whether rent payments were due and whether there was a valid lease. I mean, the biggest problem that I have and we have in this case is the process.
Well, let me ask, if there is no lease, I mean, these are new, your appellee, they now own the property. They bought it from somebody who was a successful bidder at a foreclosure sale. All right, so they come in and they don't think you have a lease. And you're in their property and they have no understanding as to how you have a possessory right to be in that property. Why can't they change the locks and kick you out? I mean, you know, if I came to my home, that my wife and I were away on vacation, I came home and somebody was in there. And I didn't think they had any right to be there because I didn't ever met them before. Let's say my hypothetical. If they leave, why couldn't I change the locks and say, you know, you can't come back in my home because I don't know who you are.
Well,
I
first,
mean, I know you're going to say that's not the facts of the case, but you know, as judges, I get to make up hypotheticals to try to get to a principle of law that I think is critical here.
well, I mean,
Because let me end that and I'll let you finish. It seems to be your premise that or do you agree that if you really have no right to be in the property and they were absolutely within their right to say, you guys are trespassers, I'm going to change the locks so you can't get in, you really don't have a claim anymore for unlawful detainer or trespass or breach of quiet enjoyment, do you? I mean, didn't you concede that?
no, Judge. In fact,
You have a
Even-
right to pursue breach of quiet enjoyment on a piece of property of which you have no possessory interest in?
let me amend that. I would concede that if we had no colorable claim.
Well, I understand that. I mean,
Yeah.
my point is, their position is you guys don't have a lease with us. That's our property. You have nothing to do with it. Whatever happened before, we're a new entity. And we want you out. And if we're just going to change the locks, now you can't get back in. And if you actually have no right to be in there, your side, you, the appellant, then you really can't have an action to trespass on somebody's property, which you have no right to be in their property. I mean, that seems kind of logically consistent, right?
Well, I mean, Florida has had a consistent jurisprudence that you can't do a self-help eviction. You can't.
But if you
just-
don't
Yeah.
live, but if you don't have a right to be there,
Self-help eviction assumes there's a tenancy.
right?
But even, I don't believe, even if you had bare possession, I don't think you could, under
So
those.
if I have my home and somebody moves into my home when the 2 weeks that my wife and I are gone, I have to sue them to get them out of there?
Sometimes you do. And
Really?
in fact, in my experience, what happens is you file an unlawful detainer action.
So where do I have to stay while they're living in my house, in which they have no right to be?
I don't know.
Okay,
know the answer to that
I'm
question.
wondering where we're going to rabbit.
All of your claims, as I see them pled, were based on the supposition that there was in fact a lease. I didn't see any claims saying I was a squatter and I had squatter's rights and they improperly ejected me as a non-tenant squatter. So at least your claims depend on there being a lease, correct?
In some respects, yes, but as far as the unlawful detainer, let's say, the lease was invalid for statute of frauds or execution issues or any number of those things. We were still there pursuant to an agreement to the prior landlord. Our position is, under those circumstances, you can't just change the locks. You have to, give the tenant or the occupier legal process.
As I saw it pled, I mean, you pled that your possessory interest was a result of a lease.
That is true.
Correct. So what I'm
Now-
saying is whatever claims may exist for somebody who didn't have a lease, you didn't bring those claims, did you?
We did not because we had a lease. I mean, that,
Okay, I get your position. What I'm saying, whatever kind of unlawful detainer or rights you may have as somebody who did not have a lease, you didn't assert those rights here because you only pled rights under a lease, right?
correct. Now, part of the problem, again, I've never been able to get to this point, was simply the way the process worked out, which, some of it I can't undo. It was addressed in the interlocutory appeal. But this idea that on the one hand, we're going to say there is a lease, you have to pay rent based on the lease, and then turn around later and say there is no lease.
But also, I looked at that statute. It doesn't say when there's a lease. So the statute requiring the payment of rent says when somebody brings a claim for breach of a lease, you can make them pay rents into the registry. Right? It doesn't say that claim can't be brought in the alternative. It doesn't say there actually has to be a lease. It says in a claim which an action which includes a claim for possession of real property. The tenant shall pay to the court registry the amount alleged in the complaint is unpaid for such amount as contested, such amount as determined by the court. So a claim, you completed the alternative in Florida, right?
Yes.
So when the statute says you can be made to pay rents when there's a claim for breach of a lease, pretty much. Does it say that can't be a claim brought in the alternative?
No, and we're not saying a claim can't be made in the alternative. What we're saying is you can't get relief based on opposing factual findings, which is what happened in this case. If the court finds my client, gives judgment to the landlord for possession, and because we didn't pay rent.
Well, hold on. They don't have, the court didn't have to find that there was a lease in order to make you pay rent. It just had to find that there was a claim against you for breach of the lease, right? It doesn't say that can't be in the alternative to a primary position that there is no lease. So I don't see what's inconsistent or disingenuous about saying, we don't think there's a lease. But in the alternative, if there is, we bring a claim for breach of the lease. Oh, and by the way, there's a statute that says if we bring a claim for breach of the lease, you got to deposit rents. And if you don't, you get kicked out. Like what's the dishonesty there?
I think me personally, I think the law provides that, you have to pick a train to ride. You can't simply say.
Isn't
when-
that the opposite of pleading the alternative?
Counsel-
Isn't the whole point of pleading the alternative is that you don't have to pick a train to ride?
Eventually, when it comes to the remedy, you do.
Counsel, you're pretty far into your rebuttal time.
I guess what I'm saying is the remedy that was here that you say they got did not require a finding that there was a lease. It only required a finding that there was a claim for breach of a lease. So to say they succeeded on a lease is just not true. The statute doesn't require a finding there be a lease.
All right, I have like 28 seconds.
Counsel, I'm going to credit you 3 more minutes on your rebuttal and I'll give the same amount to your opposing counsel.
Okay, I'd rather not stop. But do I get to, okay, if I go back and I'll have 3 minutes?
Yes, sir.
Okay, I'm sorry, I didn't mean to cut you off. Do you want me to?
Would you like to answer Judge Mize's question
If you'd like
now?
to answer, you can.
Or do you want to sit down and think about it?
Yeah.
Yeah,
However you want to handle it, it's your time.
May it please the court. Drew Chisonic on behalf of Appellees 2407 Periwinkle from the law firm of Adams and Reese LLP. With me is Scott Hertz as co-counsel sitting at counsel table.
Counsel, can we start with the basis of Judge Mize's question? Under the statute 83, 232, does there have to be a lease to get relief?
No, Your Honor, we do not believe under the statute, under a plain reading of the statute, that there is no requirement for a lease to be placed in there. And we believe that the lower court ruled correctly in finding that in the alternative or the pleading in the alternative that the plaintiff, or in this case, the alleged tenant or supposed tenant, claimed we're here under a lease. The landlord owner claimed was consistent.
Does it matter that the statute refers to the owner as the landlord? Does that imply the presence of a lease, just the terminology of landlord?
I don't believe so, Your Honor. I'm not aware of a definition of landlord under the Landlord Tenant Act, but I believe just as being a landlord, it's still again being pled in the alternative, where in this case, the owner is claiming we don't believe there is a lease person who is claiming possession. But if you believe there is a lease, then the statute mandates that you have to put rent into the registry of the court. And the legislative intent behind that statute is to protect owners from dubious claims where it gets drawn out in legal proceedings. And then at the end, there's no recourse for the owner to recover either possession. And it's just the right to possession of the property. Now, what's important in that statute is if you don't pay the required rent into the registry of the court, then it is an absolute waiver of your defenses. So a lot of the defenses that are now being raised or were raised throughout the lower court and are being raised in now the 2 separate appellate briefs go back to that. Well, if you wanted to raise these defenses, you have to pay to play the game. To point to your point, Judge Mize, if there's any legal precedent about rent paid to a prior landlord carries over. No, there's not. There's no legal authority that paying rent to a former landlord or former owner twice removed, let alone claiming credits for legal services. I think that's also an important distinction to say, well, we paid the prior landlord. No, you really didn't even pay the prior landlord. The record makes clear that the landlord or the previous owner was an entity owned by Mr. Phoenix's wife, and he was a manager of that entity, and it was credits for legal services for.
Does that matter?
I'm sorry, Your Honor.
Does it matter whether it was credited in the form of legal fees or if they paid cash to the former landlord?
No, my argument is it would not, Your Honor. I was more so attacking the point of the appellant that they paid money out. I don't think it matters one way or
So
another.
how does that attack their point that they paid if it doesn't matter what they paid in legal services?
Well, because
I get your point that it doesn't transfer over. But the fact that they paid it in legal services, if that has no legal meaning, I don't see how it's attacking their point.
it was more so touching, I guess I'd be venturing.
Is that more like kind of an issue of fairness that you wanted to bring up that doesn't have any legal relevance?
Not so, yes, Your Honor, and I guess I'd be venturing a little bit into Judge Lambert's hypotheticals. There are a lot of hypothetical things that could have been done in this case. We put it in the answer brief. There could have been a cause of action for reformation. They could have reformed that lease at issue to say, yeah, this is what we intended. That's being argued now, but that's not what the amendment says. So again, under the hypotheticals, and same thing, a claim could have been brought against the prior landlord, as I believe you mentioned in your direct examination of opposing counsel. Well, wouldn't you have a cause of action against the former landlord for advanced rents or rent credits or monies paid out and not, returned? So I was more so just wanting to highlight that distinction, that there wasn't actually money changing hands, and that was never,
Is that a legally relevant point in any way?
legally relevant to our answer brief note. Moving on to the second point, or going back to the standing argument. There, and Judge Miza, you took a lot of my talking points, so I'm not going to reiterate on a lot of what you already touched on. But there was no standing for this lease. There was no pleading in the alternative that the plaintiff in this action had an oral lease, that they were there under some alternative theory. They could have pled it. Absolutely, they could have pled in the alternative. If the court finds that the lease is not valid, we were here under, a holdover tenant, carryover, oral lease. All these things could have been pled. They weren't. They're not properly in the record before the court now for you all to make your decisions and determinations. Judge Nardella, you did have one question citing to the record whether the motion for fees was in the record from the second DCA.
Mm-hmm.
It is not, but I did want to highlight it because under
Well, counsel, if it's not in the record, then that's no need, but we just have the order from the second DCA, obviously granting the motion, which is not in the record.
Yes. Okay. So it is not in the record. And I will say throughout the case and after the final adjudication that found there was no lease, the owner moved for fees under 57-105 for sanctions, but not under the lease. So there is no, toe stepping on.
No,
each
I
side.
understand. And the same was done here.
Okay, yes, and that's what I just wanted to highlight that as far as the prejudice. I felt like that's where Your Honor was going to go with your question.
Well, it seemed like part of your opponent's theme was a judicial estoppel theory that's saying you went to the second DCA. Plus, the fight was over the monies that were required to be deposited into the registry for rent, and then the final judgment of possession. And they didn't pay the rent into the registry, and that was up on appeal, and they obviously lost that by the PCA. But there was some reference in some of the briefing that there was a motion for appellate fees that was granted by the second DCA pursuant to the lease. So I think if I glean from part of your opponent's argument is that, well, you benefited at the second DCA by asserting there was a lease between the parties, therefore you got fees awarded by the second, and now you then come back later and convince the trial court that there was no lease. How can isn't that judicially a stop from taking a position in which you benefited, and then arguing to the trial court successfully, there is no lease, you can't, they have no claim on a lease against us. And why wouldn't that be a judicial estoppel, regardless of whether they're a valid lease at all? I think that's what I gleaned, what I thought, for lack of a better thing, was perhaps the most intriguing argument here.
And if that's actually what occurred, Your Honor, I would agree that would be a problem for us to be addressing here.
Okay.
What ultimately happened was
Well, if it's not in the record, then following your Judge Nardella's lead, then, we don't.
If you have a
the Supreme
response-
Court tells us we can't go count a fish around.
If you have a response that pertains to things in the record, I'd love to hear it.
in
If whatever you were going to say is about something in the record, feel free to tell us. If it's not, then obviously don't.
I'm trying to think of the one thing I want to say. I'm trying to think if it is in the record, and I think it is loosely. And I will say that it was only pled for entitlement, because at that junction, when we're having an appellate or an appeal on possession over, what was done under Statute 83, the Landlord Tenant Act, the landlord or the owner was not yet sure that the lease was invalid. There was no adjudication on that. There was just.
You don't think you were taking perjurious positions, if I'm reading the brief from your opponent, that, you know, basically your position in defending the suit brought against you was there is no lease. But oh, by the way, if for some reason that trial judge doesn't quite see that way, then, you know, if we're stuck with a lease being forced upon us, then this guy ought to pay rent as we go through this. So I'm going to plead in the alternative, which I should be permitted to do under the Florida, you know, Florida jurisprudence. That was the context of what you did below.
Precisely, Your Honor. And then moving forward, taking that a step forward, the claim for fees would also be if the lower judge, trial court judge found that there was a lease, we still could have prevailed under the lease. And in Florida, it's very clear, if you don't plead for fees, you don't get them. So asking for fees at the onset, saying, well, if there is a lease and the tenant is required to pay rent, but then they're ultimately unsuccessful, we can prevail with procuring our attorney's fees and costs. That is drastically different than what was relayed in the briefs that we had one toe on either side of the line the entire time.
So counsel, if I understand your argument, you're saying that the second DCA's order granting fees was justice to entitlement, therefore it wasn't final. In some ways, you could still go back to the trial court and pursue fees on that ground if you lost the question of whether the lease was enforceable, or on other grounds as you did, because you had multiple grounds in your claim for attorney's fees. Is that your position?
Yes, Your Honor. And it's also, and that's what, so I'm trying not to say things that aren't in the record, but in the record below, you will see there was never an order or the owner never sought a judicial determination for an amount of fees.
So there's been no prejudice suffered if that position was taken.
Correct. Exactly.
Understood.
There was throughout the case, there has been arguments for entitlement, perhaps under different theories. Yes, but that is allowed. There is no prejudice there. Now that the position of the lower court was that there was no lease, that is why there is no motion for fees subsequent to the final orders that we're here on today, arguing
But there's a
entitlement.
motion for fees for this proceeding, but it's not related to the lease.
Correct, Your Honor. It's under 57-105.
Counsel, I know this isn't your client, but if you could, if we were to find, for instance, that there was not a valid lease, and therefore were to affirm ejectment, what prejudice would be suffered by your opponent for the prior finding granting a default possession on your motion to deposit?
Sorry, Your Honor, can you say if this court finds there was a valid?
If we were to
lease?
say, let's say they are contradictory, right?
Mhm.
What would be the prejudice suffered by your client if one of those avenues was good?
I don't think there would be any prejudice, Your Honor, because that would fall back onto effectively, and this was the final point of my argument, our re-foreclosure action. The tenant had an opportunity to redeem. There was a re-foreclosure. We actually went out and sued the two tenants. We brought them into the lawsuit, the two parties that actually signed the lease. They never appeared. They didn't respond. They were properly defaulted and they were re-foreclosed. So we do not believe that there would be any prejudice because there was no legal right to be there. And assuming that if the lease was valid, then the tenant was required to place the rent into the registry of the court, or it's an absolute waiver. And I had this come up in a different case, but that waiver even goes prior, such as notice requirements, a defective 3-day notice. You still have to pay to play the game, as you know, my terms, that in order to preserve these things, you would need to pay. Here, the record shows that the landlord or the owner believed that the tenant had abandoned the property when the locks were changed, you know, contrary to the statements of opposing counsel. There weren't, yes, there was some furniture in there, not desks set up, computers set up. It was effectively trash. And the record also shows that the principal, Mr. Phoenix, never came and picked up the property. It was,
And they were given notice of it. So irrespective of how the changing of the locks, whatever, and all their stuff is locked in, the record shows, and the court found your side gave them notice saying, come and get your stuff. And they never got it.
Precisely.
So the affirmance of the conversion claim, that's in essence separate to the discussions we've had for the last 40 minutes or so.
Correct, because that's more so personal property.
Right.
We're delving into more personal property as opposed to possession. Judge Lambert, I did want to touch on something that you did bring up in your initial questions to opposing counsel, which when you were talking about the statute of frauds in the lease, that again was pled as an affirmative defense. The statute was not retroactive in nature. At the time the lease was signed, it did not follow the necessary requirements to be a valid lease, and it was never recorded. And so these are all arguments made in the alternative, but each one of them can provide a fatal blow to the plaintiff's position. You have the standing argument that stands alone. It could have been a valid lease, but they don't have standing to enforce it. You have the fact that it's an invalid lease because they did not follow the statute of frauds and it was not recorded and it didn't follow the statutory requirements. You then have the abandonment argument separate, that if it was a valid lease and they did have standing, they've effectively abandoned it when they were arguing with the bankruptcy court that they had moved offices and they were and they were relocating. Rent was not current. Judge Mize, you did point out that there was no performance to my client, to the current owner of the property. There was never any rent paid to our side of the table. There was never any performance under the lease. So each one of those avenues provides a different legal theory, but it gets us to the same conclusion, not to mention the re-foreclosure count that kind of sweeps up everything again at the end. It says, hey, if all these things were accurate, if you had a valid lease, if you had standing to enforce it, and if you had not abandoned the property, you've now effectively been re-foreclosed out because you had an opportunity to redeem, waited the required 45 days, no party redeemed the lease. The actual tenants did not appear in the lawsuit to challenge any of these findings. And we've all read the record and we're all aware that it was Mr. Phoenix who was the individual behind the scenes pulling the strings for landlord, correct tenants, new parties moving into the property. So from the owner's perspective, I don't want to say inability, but the fact that he didn't make certain.
He caused his own problem.
Correct. He could have made these things very simple. The lease was signed the same time, the right hand signed his signature, the left hand signed his signature as landlord and tenant. The reformation, I mean, there's so many different hypotheticals that could have happened that the plaintiff would not have been in the position it dug itself in. And again, pointing one more point that Judge Mize made was every cause of action in the complaint referred back to the lease. Everything was citing back to the lease, that the lease needed to, that under the rights to the lease, they could do these certain things. Could have been pled in the alternative. It wasn't. There's also the additional comment on in the lease, it requires the landlord's approval for subletting or assignment. So even if this court were to believe, well, maybe this amendment could be seen as, bringing in now this plaintiff as a tenant, there is no record evidence that there is a writing from the landlord approving the assignment.
Did the lease require the landlord to approve assignments?
Yes, it did, Your Honor. I can give you a record site if you want.
Yeah.
Sure. One moment. R41. And then coincidentally, paragraph 41. So under that subsection of the lease, it does require that the landlord approve in writing for any assignments or transfers. And it is uncontested that there was absolutely no writing to confirm that the landlord would have approved of the transfer, even if the amendment, if the court were to assume the amendment did what the plaintiff is arguing, and that it wasn't just an amendment, it was also an assignment, a novation, all, swooped up in one. And the last point I will make, if I know I have about 4 minutes left, I probably won't use all of it, but I would have been perfect on 20 if I didn't have the 3 extra minutes. But the last point I'll make is I heard opposing counsel make an argument that, well, the owner doesn't have standing to make a standing argument. And just 2 points to that, I believe Judge Mize, you did flush it out. Well, if you're suing us saying we own pursuant to the lease and you now own the property, or we are possessing pursuant to the lease and you own the property, you abide by the lease. We're now stepping in the shoes of the landlord. So we do have standing. And I will also point out that that was not properly preserved for appeal. That's nowhere in the lower court. That's nowhere in the record arguing that the landlord or the owner didn't have standing to raise a standing defense. And then last point, the oppositions to summary judgment, the affidavits that were filed in the lower court did not raise a majority of the arguments that are being raised in the briefs. And those are two of the key orders on appeal today, the two separate summary judgment orders. And so when you're looking at the summary judgment affidavit and the evidence in opposition, we do believe that the lower court was correct in granting summary judgment, finding there was no valid lease, finding that the tenants were not proper parties, and we would request that this court affirm the lower court's decision. Thank you.
I have only a couple of minutes, and one thing I did want to point out that the issue of the existence of a lease and whether or not the tenant was in possession of the property and it wasn't abandoned. I mean, the courts actually made a specific finding. It stated that the new owner took ownership of the property under the terms of the lease. That's what the court said. And that's in some ways underscores the frustration that my clients have. In part, it's due to the kind of the backwards way this happened. These, in my opinion, these things should have been handled all together, but instead what happened was, Judge?
Oh, counsel, if we were to accept your opponent's argument that all roads lead to Rome, right? That there's multiple roads to get to where they got. If one of those roads are good, if we were to accept that argument, what would be the prejudice suffered by your client?
Well, I mean, I think you have the difference between, keep in mind that my client was an operating business as of the time that they were locked out. So, and that's why we had a damages claim. That's why we had the trespass claim. They suffered damages, and, from our perspective, we were never given a hearing on that. Notwithstanding the fact that we submitted evidence to the court supporting our position. So yes, there would be prejudice. My
But
client,
the failure to have a hearing, that would be on the first claim for the motion to deposit the registry when you wanted to determine the amount. Is that where you're claiming a lack of process?
that and the subsequent proceedings wherein the court, in our view, went directly contradicted itself and said that there was no lease. And the landlord gets to show up,
Counsel,
change the locks, and take your stuff.
these are summary judgment orders, right?
Yes,
So we're looking at them de novo.
yes, Judge.
Does it matter if the trial court's contradictory, or aren't we just supposed to figure out what the right answer is?
Well,
The trial court made mistakes, but it got to the right result. What do we do with those mistakes on a de novo review?
Well, I also believe that there was material disputes of fact in the record that could have, at least given my client a fair hearing so that they would have had the right to damages if they were correct. That never happened. So how much time? Okay, 47 seconds. So anyway, part of the problem here in our view is, I feel like, my client feels like the court just did what was expedient to get them out of the property. That's the way they feel, and I think that the record bears it out. It could have been decided altogether, but instead, what happened was, because of the ex parte order, that basically made everything go away without a hearing on the substantive merits of the case, and that's.
Well, I mean, but if you don't pay the rent pursuant to the order to deposit it, they're entitled to get possession, right? You don't have to have a hearing about that, do you?
That's true, Judge. However, keep in mind that they were not in possession. They had been locked out. The court was asking them to pay rent for something that they didn't have.
But you were claiming possession, and that's why they sued you to say you're not entitled to be there anymore. And you had to deposit money into the registry of the court. And then when that didn't happen, then they followed the statutory procedure to get a final judgment saying you don't get possession anymore, and then you can still litigate your other damage claims or other causes of action. And that's what you all addressed with the second DCA and unsuccessful. You know, kind of what happened.
Right, but we would have been entitled to, in our view, entitled to an actual summary judgment hearing that considered our evidence, which we didn't think
You had a
was
summary
considered.
judgment hearing.
We did have a hearing, but our evidence was ignored. There were clear disputes of material fact. Thank you, Justices.
Thank you for your time today, council. We are adjourned.